Thank you so much for this opportunity to be here today. I am State Senator Lisa Krasner, proudly representing State Senate District 16. I'm here to present Senate Bill 95. It is my honor to be here today, and Senate Bill 95 revises provisions governing military justice. A little bit of background information. The Nevada National Guard, consisting of citizen soldiers who balance civilian lives with military duties, plays a crucial role both in national defense and domestic disaster response. Ensuring that military justice effectively protects these service members, particularly regarding sexual assault, is paramount due to the unique challenges they face, including potential conflicts between state and federal jurisdictions. While the National Guard Bureau has taken actions to combat sexual assault, there has been a continued flow of National Guard sexual assault reports. In light of these issues, it is ever more important that our brave service members are sufficiently protected and have judicial remedies to address corrective actions. In contrast to civilian systems, where punishment is reserved for judicial tribunals, military justice systems allow non-lawyer military leaders to administer non-judicial punishment for some offenses. While our federal service members are generally allowed to request courts-martials in lieu of non-judicial punishment,
Senator, please continue.
Thank you, Senator Flores. Excuse me, Chair Flores. While our federal service members are generally allowed to request courts-martials in lieu of non-judicial punishment, the states are divided on whether National Guard service members can decline non-judicial punishment and request a court-martial. In Nevada, the right to demand a court-martial in lieu of non-judicial punishment was first granted in the 2015 Nevada legislative session at the request of the Nevada Office of the Military. That was Senate Bill 90, 2015. It appears that bill in the 2015 legislative session requesting that members of the Nevada National Guard be allowed the choice to demand a court-martial in lieu of non-judicial punishment was to bring the Nevada National Guard in line with the active duty United States military justice system. The fiscal note for the 2015 bill, Senate Bill 90, a very similar bill to this bill, SB 95, estimated a fiscal note of zero cost to the state of Nevada. The choice to demand a court-martial was eliminated in 2019. According to the testimony by the Office of the Military, the reason why it was introduced was to eliminate the right to demand a court-martial and found that the resources to conduct a court-martial were prohibitive and impractical. This bill, Senate Bill 95, is inspired by cases like Allison Bailey's, a Nevada National Guard member whose tragic experience underscores the need for transparency and due process under the Fifth Amendment to the United States Constitution. Bailey faced severe administrative punishments without access to a court-martial after she reported that she was sexually assaulted within her unit. Her story highlights the risks of relying solely on a non-judicial punishment process, which can lack accountability and fairness. The non-judicial punishment does not afford the accused serviceman or servicewoman of the Nevada National Guard with protections that a court-martial would, such as no rules of evidence apply to a non-judicial punishment, meaning hearsay and other unproven claims can be made. Also, there is no Sixth Amendment right to confront witnesses against you. Also, they have a right to counsel beforehand, but they have no right to legal representation at the hearing where they defend themselves against the charges. These legal protections are included with a court-martial. While this bill will not bring Allison Bailey back, it will apply to members of the National Guard, the Nevada National Guard, moving forward. Moving forward with this bill, our members of the Nevada National Guard will have these protections in place. They will have the ability to have due process. They will have the ability to demand a court-martial in lieu of the non-judicial punishment if they would like. Senate Bill 95, the bill before you today, provides an accused serviceman or servicewoman of the Nevada National Guard with the right to demand a trial by court-martial or accept a non-judicial punishment imposed by a commanding officer. Now, I was going to talk about the fiscal note here, but many of you have seen this on your desk. It should be on your desk in front of you. I just received this a couple hours ago. And this is by the Legislative Counsel Bureau here at the Nevada Legislature, Wayne Thorley, the Senate fiscal analyst. And if I can draw your attention to the third paragraph, they do talk about the fact that there was a zero fiscal note in the 2015 legislative session. They talk about the fact that even though during the years between 2015 and 2019, Nevada National Guard members had the opportunity to request court-martials, none were requested. And so given all this, it is uncertain what fiscal impact, if any, there would be on the state if Senate Bill 95 passes as introduced. Given the lack of any trials requested or given between 2015 to 2019 under the prior law, it is possible the fiscal impact in any given year may be closer to zero than the $1.2 million estimate provided by the Office of the Military. In situations such as this, where future costs are unknown, but could conceivably be at or near zero in any given fiscal year, the legislature has the opportunity to pass this bill without additional funding attached. It's there for you. This bill is now moving forward with a zero fiscal note. In closing, SB 95 intends to provide greater protection, due process, and legal recourse for members of the Nevada National Guard when facing disciplinary action. A fair and supportive justice system is essential to maintain the National Guard's readiness, foster trust among its members, and uphold the integrity of the armed forces. For those reasons, I would appreciate your support of SB 95. Additionally, Chair Flores, I have four co-presenters. 2 are on Zoom and 2 are with me today. If I may, I would like to start with Colin Kavanaugh, and go ahead and press your button and then state your name, please.
Thank you, ma'am. My name is Colin Kavanaugh. I am the brother of Allison Bailey, who was mentioned several times so far. My stepmother, Felicia Kavanaugh, has asked that I read this testimony as they are on the Camino del Santiago, which is a religious pilgrimage. It was something that Allison was interested in shortly before her death, and so they are on this journey with her significant other, Sam Boyd Jr., in honor of her memory. And so unfortunately, this is the only time they will be able to complete the pilgrimage, as Allison's significant other, Sam, is also in the Nevada National Guard, and he will be deploying. So she apologizes for her absence, but you'll hear her testimony, I would imagine, in just a few moments. But as stated, my name is Colin Kavanaugh. I would like to thank the committee for hearing SB 95, and I would like to put a special thanks forward to Senator Krasner for putting forward this bill, which would be a landslide victory in the rights of our service members in the state of Nevada. I am a firefighter with the city of Reno. I also served 6 years in the Nevada Air National Guard, enlisting at the age of 19. I grew up watching Allison serve in the Nevada Army National Guard, where she was regularly at our house for dinner in uniform, and she was clearly dedicated to serving her country and her fellow soldiers. As the older sibling, Allison was a major role model for me and was a large reason why I joined the Nevada Air National Guard. On the day I enlisted and swore in for duty, Allison was standing there in uniform beside me. During basic military training, everyone is taught to deeply fear the Article 15 and other punitive actions that can occur to you in your service. We're taught that the principle of court-martial is one of the only forms of recourse and representation that we can have in the punitive process. It's deeply disturbing to learn that an enlisted Nevada National Guard member can be found guilty of undocumented allegations and be disciplined to the extent that Allison was, with no right to request a court-martial. I had no knowledge of this when I enlisted in the Nevada Air National Guard, and during my time, I had no idea that court-martial was not a right that would be afforded to me during a disciplinary process. If I had been aware of this lack of judicial fairness, I don't know that I could have had the faith to enlist or recommend that many people enlist, as I have done to so many young people. What I know now is that the current practice of no court-martial allows years of excellent service, as in Allison's case, and in fact one's entire career to be placed in serious risk by not affording members the same right to a court-martial that they would have in the active military or most other states. I have very good friends still serving in the Nevada National Guard. It is for them and all enlisted military in Nevada that I support SB 95. Those who voluntarily serve deserve the same justice as the Uniform Code of Military Justice provides to the remainder of the military and that the Constitution provides for civilians. As proud Nevadans, I implore you to push forward SB 95 and support your Nevada veterans and service members.
Senator Chair Flores, next I have Assemblyman Ken Gray, please.
Good afternoon, Chair, Senate members, Assemblyman Ken Gray for the record. I represent Assembly District 39, all of Douglas County and the Central Lyon County corridor. I spent 26 years in the military, about my last 8 with the Nevada National Guard. I currently still have a daughter serving with the Nevada National Guard and many, many friends still serving with the Guard. For that reason, I'm very, very proud to sit here next to the Senator and support SB 95. This bill is paramount to military fairness as it pertains to justice. It's a very important check and balance. I'm not sure which of you guys are lawyers, but the bar for proving something for an Article 15, the non-judicial punishment, there is no bar. So if a member that's been basically charged with something after a hearing opts to go for the court-martial, the presiding authority, that commander, has got to be able to prove at that point, beyond a shadow of a doubt, the charges he's levied against that individual. So it's a great tool for an enlisted guy to say, or even an officer to say, I'd rather take the non-judicial punishment. I know I did it. They've got the evidence. Or I didn't do this, or I didn't do this the way they said, and there's no way they're going to be able to prove it, or the punishment will be less. So it's a very important check and balance. I'm going to forego the rest of my testimony because I've got a letter that I received this afternoon from Major General Baldwin, the just recently retired Adjutant General of California. And I want you to put some numbers in perspective. Their force has 24,000 troops. Ours has 4,400. And I'm going to cover some other statistics in this letter, and it will verify that fiscal note is far closer to zero. I mean, within dollars probably, than it is the $1.2 million they put on it. And we should never forego, especially as soldiers and airmen of the National Guard, forego our constitutional rights because of a lack of resources. That's not the American way, and that's not what we signed up to do. Dear Assemblyman Gray, I write in strong support of Senate Bill 95 to restore the due process rights of Nevada National Guard soldiers and airmen to be able to demand a trial by court-martial when faced with non-judicial punishment. The constitutional right to due process should be afforded to members of the Nevada National Guard that have sworn to support and defend our Constitution. I served for over 40 years in the California National Guard, including over 11 years as the state adjutant general. During that time in California, we used a system of military justice mirrored exactly after the federal military justice model. And I do want to bring back to this body, we passed a law one session ago that I had brought that actually had us bring parity for the service of major generals, taking them to age 65. So this body has a history of parity between the federal service, or seeking parity between the federal service and state service. So this included the right for personnel facing non-judicial or administrative punishment to demand a court-martial in lieu of an administrative proceeding. That system worked very well and protected our soldiers and airmen's constitutional rights. Nevada should adopt the same system for their Guard members. The cost to the state of Nevada for allowing accused military personnel to demand trial by court-martial would be negligible. During my tenure in the Guard, commanders at all levels took hundreds, if not thousands, of non-judicial punishment actions to maintain good order and discipline. Yet I am only aware of one case during that 40-year period that the member opted for court-martial. The costs for that court-martial were borne by the federal government. I personally administered scores of non-judicial punishment actions during the 20 or so years I held command positions, and none of the people I punished chose to ever exercise their right to a court-martial, but they had had the option to do so, unlike counterparts in the Nevada National Guard. The Nevada National Guard can use federal funding that's available under Title 32 of the U.S. Code to fund the personnel costs associated with conducting court-martials. The National Guard Bureau can provide federally funded defense attorneys to represent the accused at no cost to the state, and large states like California can loan federally funded military judges to preside over courts-martials in the rare instances that the need arises. The Nevada National Guard needs a complete military justice system to maintain the good order and discipline necessary for the organization to execute its vital state and federal missions. SB 95 will help complete that justice system and restore the constitutional right to due process to the men and women serving the Nevada Guard. Sincerely, David Baldwin, Major General, United States Army, retired. I present this because he is, out of everybody in this room and everybody that's going to testify on this, is the foremost expert. 40 years of service and presided over many, many more of these instances than anybody in this room will ever hope to. So please consider that when you're addressing this bill. And remember, they will have the option, but it will probably never be, that option will probably never be selected because it is a check and balance. Thank you.
Chair Flores, there are two more co-presenters on Zoom, please.
Just before we go to them, do you want them just to come in and support or ask general questions? I'm assuming they're just going to testify and support it, or are they going to get into
No,
the
they're
technical parts of the bill?
co-presenters. They're co-presenters on Zoom.
Just for the sake of presenters, if I could have you just focus on the technical parts of the bill. I want to be respectful of the committee's time. If you want to dive into the bill and just really hone in on the sections that you'd like to address, whoever wishes to go first.
Can you hear me?
Yes, I can. Welcome.
Good afternoon, Senate Government Affairs Committee. My name is Felicia Kavanaugh, and I am an Air Force veteran and the mother of Sergeant First Class Allison Bailey. Allison passed away on March 4th, 2023, just 6 weeks after being discharged from the Nevada Army National Guard, where she earned a Good Conduct Medal and received glowing performance reviews. We spoke daily, and on multiple occasions she expressed her frustration with the change in Nevada law that stripped away the right to court-martial. Allison believed this change violated the Uniform Code of Military Justice, the cornerstone of military law. And it is for this reason that I reached out to Senator Krasner and asked her to sponsor what is now Senate Bill 95. Senate Bill 95 seeks to restore the right to court-martial for Nevada National Guard members, ensuring they receive the same legal protections as those serving in active duty military branches. The U.S. Constitution, Article 3, Section 2, guarantees the right to a jury trial, stating, "The trial of all crimes shall be by jury, and such trial shall be held in the state where the said crimes have been committed." Allison was denied this fundamental right. She was found guilty of 22 violations of Nevada law, despite there being no tangible evidence to support the claims when the alleged offenses took place. The accusations only emerged after she filed a complaint against her commander. Allison wanted a trial to challenge what she saw was flaws in an investigation against her and to prove her innocence. We will never know if she would have been found guilty had the full legal protections available to other Americans been applied. Instead, she was demoted multiple ranks without oversight, due to the legal restrictions on how Nevada Guard members can challenge accusations and punishment. This unfair process ultimately led to her being denied a medical discharge, losing her career and health care despite being critically ill. Restoring the right to court-martials in Nevada will not only honor Allison's memory, but will also save the state money and strengthen the Guard. Training Guard soldiers and airmen is costly, and when service members can be punished based solely on hearsay accusations without tangible evidence, it undermines the Guard's integrity. Nevada National Guard members deserve leadership that addresses misconduct promptly, not years later, as in Allison's case. They deserve equal justice, not a second-rate version of it. I urge you to support Senate Bill 95. Passing this bill will protect the rights and dignity of all Nevada National Guard soldiers, past, present, and future. It will ensure that no other family faces the heartbreak and injustices that we've endured. Thank you.
Then I think we have somebody else joining us on Zoom.
Yes, Senator.
Please proceed.
Chairman Flores, members of the committee. My name is Christopher Tinsman, and from 2013 to 2022, I was a military attorney in the Nevada Army National Guard and U.S. Army. I was Allison Bailey's military attorney through her non-judicial process. I tried several court-martials and overseen a large number of non-judicial punishments as a military attorney. I appreciate the opportunity to speak today to help introduce Senate Bill 95. It's a critical piece of legislation that will restore the due process rights of soldiers and airmen in the Nevada National Guard in cases where they face non-judicial punishment. The bill is necessary because it restores to the Nevada Guardsmen who have sworn to uphold and protect the constitutions of the state of Nevada and the United States the due process rights that they are protecting under those documents. Right now, a soldier can face punishment without the rules of evidence, an impartial fact finder, the ability to confront witnesses, and a host of other rights that are basic, almost implied, in any other judicial process in the country. Without this reform, not only is the soldier faced with punishment without the benefit of due process protections, but commanders and even the military attorneys practicing military law do not learn what right looks like in the rest of the U.S. military. This bill would bring the Nevada Code of Military Justice in line with the basic protections offered by the U.S. Army and the U.S. Air Force at the national level. Senate Bill 95 offers a practical solution. It provides the ability for soldiers and airmen to turn down non-judicial punishment in favor of a court-martial. At a court-martial, the soldier would have access to those due process rights available to anyone subject to criminal sanctions in a U.S. court. This process is fiscally responsible, operationally effective, and forward-thinking. Ensuring that soldiers and airmen are protected, the commanders and military attorneys are trained properly for their state and national missions, and the Nevada National Guard is made better as a whole. Support for this bill is broad and should be nonpartisan. The Department of Defense can and must provide funding for courts-martial, even at the state level, and the vast majority of state governments provide equivalent protection to their soldiers and airmen through the right of turn down outlined in this bill. Furthermore, it aligns with policy and practice in place in the U.S. Department of Defense, going back to the beginning of the the Uniform Code of Military Justice. In short, Senate Bill 95 is not just necessary, it's the right thing to do. I urge this committee to advance the bill and take a decisive step toward providing soldiers and airmen their basic due process rights and making the Nevada National Guard a better, cleaner, and more effective organization for their state and national missions. I appreciate the opportunity, and I am open to any questions that the committee has.
All right. Thank you all for the presentation. At this time, we'll open it up for questions. Members, any questions, please? I don't think we have any, and I know that is testament, Senator Krasner, that you've obviously had multiple meetings, you've been meeting with us individually, so I think most of us have a good understanding of exactly what you're trying to do. But I want to make sure one more time, members, any questions? Senator Ellison, please.
Mr. Krasner, when you started, I think you said you met with the governor's office, or did you not? Has this been taken to the governor's office? Because the governor's
Senator Lisa Krasner, representing State Senate District 16. Chair, may I go directly to, thank you, Senator Ellison, for your question. No, I have not gone to the governor's office with this. I have not met with the governor regarding this bill.
Governor's kind of like the commander-in-chief over the state of Nevada, which would also include the guard unit. You might want to talk to the governor, see where he stands on this. Thank you.
Any other questions, comments, members? Seeing none, thank you all again for joining us. I'd like to invite you to sit back in the gallery. And at this time, I'd like for those wishing to testify in support to please come forward, Carson City or Las Vegas. I do see somebody in Las Vegas. We'll start there, and then we'll make our way back to Carson City. Good afternoon. Welcome in Las Vegas.
Good afternoon, Chair Flores and members of the very hardworking Senate Government Affairs Committee. For the record, I'm Fred Wagar, F-R-E-D-W-A-G-A-R. I represent the nearly 15,000 members of the departments of the Veterans of Foreign Wars and the Disabled American Veterans of Nevada. When you include their families, it's about 50,000 Nevadans. The VFW and DAV support SB 95 because it seeks to restore the fundamental right of Nevada National Guard members to demand a court-martial when facing serious allegations of misconduct. This bill is not merely about procedural fairness, it is about ensuring justice, accountability, and the protection of those who serve our state and nation. Currently, Nevada is one of only a few states where National Guard members lack the right to demand a court-martial. Military commanders often conduct non-judicial punishment behind closed doors without the safeguards of a traditional trial. Guard members accused of misconduct face life-altering penalties, including demotion, confinement, loss of pay, and even discharge without the opportunity for a fair trial. This lack of a due process undermines principles of justice and erodes trust in the military justice system. We urge you to support Senate Bill 95 and restore the right to demand a court-martial for the Nevada National Guard members. Let's honor their service by ensuring that they are afforded the same legal protection as every other citizen. I want to thank Senator Krasner for bringing this bill forward and the others that sponsor the bill. Thank you for your time and consideration. We urge you to vote for this bill in honor of Nevada's service members. Thank you.
And thank you for joining us from Las Vegas. Now we'll move down to Carson City. Whoever wishes to go first, please.
Yeah, for the record, my name is Dirk Miner. Thank you guys for hearing our testimony. I'd just like to come out in support of Senate Bill 95 and just want to read this quick statement. The judicial system is a foundational cornerstone to any governing body. This institution is part of our civilian justice system as well as our federal military branches. I don't see why we would not have the same system in place for our state's military branches. The crimes committed in our state military can be as complex as any in the civilian world. Therefore, we should have a justice system just as complex to deal with these situations, regardless of a fiscal impact. Thank you.
And thank you for joining us. Please.
Hello, my name's Eddie Lindstrom. I served in the Nevada National Guard from 2013 to 2021. Before that, I served in the United States Marine Corps Infantry from 2009 to 2013. I deployed to Afghanistan twice in support of Operation Enduring Freedom. 32 U.S.C. 326 establishes a premise for a court-martial, which is the Title 32 is what federally regulates all 54 states and federal governments all 54 state and U.S. territories National Guard. 327 delegates the convening authority to the state. NRS 412.583 demands a uniformity of construction, mandating that it coincides with Title 10 U.S.C., which regulates all uniform code of military justice for federal active duty and even federal reservists. The Nevada Code of Military Justice is supplementary and does not supersede Title 32 of the USC. Non-judicial punishment, also known as NJP, currently is not implemented impartially or fairly in the Guard from what I've seen. A quick example is 25 to 2016. A group of Nevada National Guard recruiters got caught having sexual relations with minors. Some of them in the RSP and JROTC program, they were given non-judicial punishment and allowed to retire, never referred for any kind of prosecution. 2016, a master sergeant killed his wife in a domestic, was given national or non-judicial punishment and allowed to retire. He was just released from prison. 2018, a sergeant first class gets a third felony DUI causing injury, given non-judicial punishment and allowed to retire. 2020, sergeant first class and a warrant officer recruiter for the state are arrested in an FBI task force in an underage prostitution sting, given non-judicial punishment and allowed to retire. They are out of prison as well. Sergeant first class Allison Bailey reported being sexually assaulted twice by a subordinate soldier in the past year who had a history of assault with a sealed record in California, and she was denied the right to court-martial, which defied 32 USC 326 through 328, which provides federal funding if the funds aren't available. I come out in support of this bill and Senate Bill 95, and it should be passed to bring the Nevada National Guard back in compliance with Title 32 USC and give service members the unabridged right to court-martial. The bill does not incur any additional state funds, and, as federal drill checks and retirement and benefits are paid out of federal money from the National Guard Bureau. Thank you.
Who's in charge? So Senator Daley and committee, my name for the record is Andrew Lee Pilbit. I am the state chair for the United Veterans Legislative Council, representing 250,000 veterans in our state. And when you take their families into account, 500,000 Nevadans in the state of Nevada. So we represent all the joint groups of the veterans, and we meet each year to prioritize bills. This is one of the priorities that was voted on by our veterans in both the North and the South to reinstitute court-martials in our National Guard. I did a lot of the testimony, especially Fred Wager ahead of me, so we won't repeat all that. I am a combat veteran, infantry, Purple Heart recipient. I've watched our Guard people be deployed and deployed and deployed. And many of these units have been deployed 5, 6, 7, 8 times, and we're wondering why they're not doing well sometimes. They need court-martial to be in place instead of an Article 15 or non-judicial. It's the only way you can get to the bottom of some of those things and support these guardsmen and women, and they need our support, and this needs to be part of our regular operations in the Guard. So please reinstitute the court-martials, and we would appreciate it. We support the bill 100%. Thank you.
Hello, my name is David Gerhard, and just want to let you know I am in support of Senate Bill 95.
Hello, Chair and Committee. My name is Jessica Glover, JESSICA GLOVER. I am a daughter and granddaughter of United States veterans. My grandmother is a United States veteran of World War II who taught me to stand for what I believe in. As a woman, I've had to stand for my own justice. I ask you to pass Senate Bill 95 and support our servicemen who support the United States of America. Thank you. Okay.
Do you have any other testimony in support of Senate Bill 95, either here or in Las Vegas? Support in Las Vegas? No? Broadcast, anybody on the phones in support?
If you would like to testify in support of Senate Bill 95, please press star 9 now to take your place in the queue.
Hello, this is Regina Villacruz. Can you hear me?
Yes, we can. Please continue.
I'd like to thank Senator Krasner for introducing SB 95. I am currently an active duty member in the U.S. Army. I started as a reservist, but I am currently still serving. I have plans to be a resident of Nevada, but I'm expressing my support for this bill, specifically to say that the UCMJ process is for the good order and discipline in any military service. But it has a commander's role. It is used as a deterrent and holds an accountability tool. But the UCMJ principles protect the soldier and impose resolution. When that is not possible, like in the case of Allison, whom I know personally and love dearly, she was a victim of no court-martial. The court-martial process will afford soldiers the opportunity to be heard when the UCMJ process has found null results or is not in the best interest of the soldier. She gave her life, and we all do, and this SB 95 serves to ensure that our interests are protected when we face these circumstances. The court-martial process must be a right. I support SB 95. Thank you.
Any more callers, BPS?
Chairman Flores, my name is James Clark. I live in Incline Village. I spent 30 years in the Navy and Naval Reserve as a military lawyer, a judge advocate, as they're called in the service. And although I've been in the Navy, the other services have the same experience that I'm about to relate. In my case, I served as judge advocate to Readiness Command Region 19 in San Diego for 4 years. I was commanding officer of Naval Reserve Legal Service Office, North Island in San Diego, commanding officer of Naval Reserve Legal Office, Naval Base San Diego for 2 years, and commanding officer of Naval Legal Service Office, Long Beach Naval Station for 2 years. I'd just like to assure your committee that there are any number of qualified reservists and all of the services that stand ready to support the National Guard's people if they want to demand court-martial. We all take an oath to support the Constitution. Let's make sure that National Guard's people are afforded due process. Thank you.
Caller with the last 3 digits of 960, you are unmuted. Please continue.
Thank you, committee and Chair Flores. My name is Peggy Bowen, spelled P-E-G-G-Y B-O-H-N. I am a U.S. Army veteran, and I am in support of SB 95, and I agree with all the other comments. Thank you for your time.
You have no more callers at this time.
Thank you. So we'll close testimony and support, and we'll open testimony in opposition here or in Las Vegas. Anybody have testimony in opposition? Seeing none, broadcast, we'll go to the phones.
If you would like to testify in opposition of SB 95, please press star 9 now. You have no callers in opposition at this time.
Thank you. I'm guessing we have some testimony in neutral. At this time, we'll ask anyone that wants to testify in neutral to come forward, please. When you're ready.
Okay, thank you, Senator Daley. For the record, my name is Colonel Kevin Remus. I'm the State Judge Advocate for the Nevada National Guard. I've held that position since 2019. I'm a West Point graduate with 26 years of combined active and Guard service with the last 11 years as a JAG. I've deployed 3 times, including as an ETT team leader in active ground combat in southern Afghanistan before becoming a JAG. I'm a traditional guardsman with a civilian job. I felt it was important to fly up to testify as the head of the office who would carry out this law. As far as a fiscal note, we provided our best military advice. The fiscal note was prepared in consultation with a JAG who is a major crimes district attorney in Washoe County. And federal funds are allocated by the TAG and senior leaders. No federal funds are specifically earmarked for court-martial. Any federal funds used would take away from training and readiness. And this is especially important in the current resource-constrained environment in which we operate, with significant cuts being forecast with the new administration. As far as personnel, we have no full-time uniformed attorneys in the Nevada National Guard. I'm a traditional guardsman who woke up this morning in Las Vegas, worked at my civilian job, and I flew up this morning to testify, and I'll be heading back home tonight to work at my civilian job tomorrow. As the leader of the Office of the Staff's Judge Advocate, I can tell you we're already stretched thin with all of our soldier training requirements as well as our current JAG duties. We do advice on non-judicial punishment because non-judicial punishment is not conducted in a vacuum. It's conducted with legal advice. We also are responsible for fiscal advice, ethics, investigations of all kinds, and boards. 4 of our attorneys currently work at the Washoe County DA's office. Taking them away from the Washoe County's DA office for a month or more to conduct a court-martial is a difficult ask for the Washoe County DA when we have other means as traditional guardsmen to conduct military justice. Another important factor is we do not have a military judge. One of our JAGs did apply to become a military judge, but was not accepted into the very competitive program. As far as using judges from other states, the state judge advocate, which is me, is responsible for detailing a judge for a court-martial procedure.
Real quick, you're over your 2 minutes, but I'm going to let you go a little bit longer because I'm interested in hearing what part of this is, and there might be a question if anybody has one. So,
yeah, thank you, Senator. As far as using a judge from another state, that's my job to detail that person to become a judge at a court-martial. And in my opinion, due process is best served by a Nevada barred attorney qualified as a military judge. The current system we have using NJP and separation boards does involve due process. In general, due process involves notice of charges against someone, the underlying investigation that led to those charges, government-provided defense attorneys, the right to remain silent, the right to examine available evidence against someone, the right to present evidence and call witnesses. There's also the right to appeal to a higher commander and also the right to challenge board members. While it is true in non-judicial punishment, there is no ability to cross-examine witnesses. There are the other due process protections that I've mentioned. And the important thing about non-judicial punishment is it's a non-adversarial proceeding between a commander and a guardsman. A commander and a guardsman meet and discuss the issues at hand, and the goal for that is rehabilitation. At a separation board, it's a trial-like proceeding governed by Army and Air regulations. There are attorneys for both sides. There's a jury known in the military as a board of officers, and in Nevada, we often bring in a board of officers from out of state so no one knows any of the players at that board. There's also a legal advisor who decides on admissibility of evidence. That legal advisor is also an attorney. So we do believe that due process is protected in separation boards and to some degree in non-judicial punishment. As far as a fiscal note, the consequences of lack of resources as the bill passes is we will not have a qualified military judge for 2 to 3 years. Non-judicial punishment ends up going away as a rehabilitative tool for commanders to maintain good order and discipline. And the vast majority of non-judicial punishment leads to guardsmen rehabilitating their careers. So some of those guardsmen would face separation boards and be forced out of the military because there is no more chance to rehabilitate. It would have a negative impact on readiness and retention. And one other issue I'll bring up is the comparison to other states. As I said earlier, we're a small state. We have no full-time military attorneys. So I've I heard about the opinion from California. The opinions that matter are the opinions in this state about our National Guard. California is resourced far differently than us, has a far more robust legal office. So I would just wanted to bring those, resource constraints to your attention, and just to give you the confidence in knowing that non-judicial punishment is, due process is protected through the non-judicial punishment and separation board. While there aren't criminal proceedings that constitutionally require certain levels of due process, they're still provided to soldiers and guardsmen in the Nevada National Guard. And that's all I have, Senator.
Thank you. Any questions from anybody? Senator Ellison.
Thank you for your service. Looked like you did do some combat time. So the questions that I got is, you said that you had the right to bring in an attorney from another state. Is that correct?
Senator, in the NRS 412, there is an ability, Colonel Kevin Remus, for the record. Senator, in NRS 412, where there's a provision for a judge to be admitted pro hoc vice. In my opinion, I don't think that's fair to a Nevada National Guard soldier to have a military judge not barred in the state who is responsible to conduct a court-martial and make rulings on state charges. So as far as due process is concerned, a Nevada barred judge is what I would prefer. And as the state judge advocate, it's my responsibility to detail that judge.
The way Nevada is right now, we're trying to get resources from every place we can. And for the record, we have no idea what brought us to this point. That's private privy that we're not to. We have no idea, what brought it to that point. But when the requests come in for a court-martial, that's serious. I mean, something has to be pretty serious to ask for a court-martial. But I think we should have used everything we could have used for in our state, and if we couldn't done it, we went to the next state. There's a lot of big militaries out there as far as National Guards. California, there's Utah, there's Idaho. We could have asked for one of them to come in and try to resolve the issue. We don't know what it was, but what we do know is we do have resources we can pull from. And we just got out of a meeting today where the state has an indigent fund strictly for judges. So that could have maybe been an issue that we could have pulled in from. So we learn a lot every day. We learn from our mistakes. Believe me, I do my share. But I believe in our military, and I believe it strongly, but I believe our military leaders is the one that always reach out. And believe me, I had General Burke's phone number on speed dial constantly. He was a great man, and I got all the respect in the world for General Burke. So, but I'm hoping that we don't run into this again, but if we do, I ask you to use whatever resources there is to resolve the issues. That's my personal belief, and you can call any of us to help. Thank you.
Thank you. We were on the verge of a filibuster there, but Senator Rogich.
Thank you for being here and presenting and answering questions. With regard to the comment as to bringing a judge into Nevada pro hoc, is it the same with regard to a civil attorney that comes in pro hoc where they have to be supervised by a licensed attorney in Nevada?
Colonel Remus, for the record, Senator, the NRS 412 provision is not very detailed on the process, but it has to be admitted pro hoc, and I'm not quite sure about the actual procedures. It says the senior service JAG needs to admit the person pro hoc, so I don't think it's the same as going to the federal court and getting a pro hoc admission. But there's a process, and the process in 412 is kind of limited and not very clear.
I'm a lawyer, and that's why I'm curious as to the process. who actually has the oversight. So when we bring someone in pro hoc, or if I do, I'm responsible for that individual who is appearing in the courts in the state. And then also I would have to report back to the state bar in the event there's an issue. So I'm curious as to the process.
Colonel Remus, for the record. Senator, as the senior attorney and the state judge advocate in NRS 412 court martials, the convening authority, who would in this case be Brigadier General Waters, delegates it to me to organize. So I would take it as something that I would have to supervise that attorney. I would have to feel comfortable with that attorney's record qualifications. And so the responsibility for the conduct of the court martial, good, bad, indifferent, falls back on me personally.
And thank you for that. I think all of my questions have been answered. I just understand a little indulgence there on the time on the 2 minutes, but I knew we would have some questions. So with that, any other testimony in neutral? Seeing none, broadcast, do we have anybody on the phone?
If you would like to testify neutral on SB 95, please press star 9 now to take your place in the queue. Chair, you have no callers neutral at this time.
Thank you. Senator, if you'd like to come up and make some closing remarks.
Thank you, Vice Chair Daley. I'm going to allow Assemblyman Gray to go first.
Good afternoon, Assemblyman Ken Gray for the record. First, I'd like to point out, I don't know if I mentioned this before, 26 years of military service myself. I did retire active duty. I spent 8 years with the Nevada National Guard and the rest on active duty. First, I'd like to draw a point of order, if that's okay. I believe that the colonel's testimony was far more in opposition than it was neutral. So if we could have that moved over to opposition. Okay, counsel is saying no. So anyways.
I concur. We'll leave it the way it was.
Okay.
And we'll move on.
So the colonel mentioned the disparity in resources between us and California. My point was they have far many more troops than we do, and yet the general had only experienced one court martial. So I would say on a scale of numbers that we are far less likely to ever experience a court martial. It wasn't a matter of what resources they had or didn't have. It was just a comparison of the numbers. Of course, they've got more resources. That's obvious. With regards to taking the tool from the commander, the tool is obviously not needed if the individual who is being charged with the offenses is saying, I want to go to court martial because I feel I can win. If the commander at that point, I mean, when you demand a court martial, it doesn't automatically go to a court martial. That commander and the convening authority have to know that they're going to be able to prove those charges beyond a reasonable doubt at that point. That bar has just gone that much higher. I've seen more commanders back down in my active duty career than I have seen them take it to court martial because they know that they were not going to be able to meet that bar. They wanted some kind of punishment instead of no punishment. And a lot of times what they get is no punishment and everybody goes about their business. The other thing that really, I'll say it galls me in this instance where troops do not have a choice of a court martial in lieu of an Article 15 or non-judicial punishment is that you now have an individual acting as the judge, the jury, and the executioner. And what if that person is biased? What if, say, an individual that is being charged had refused advances from that commander? And he is now, I mean, you don't get to face your accuser, but he's bringing charges that are non-existent. I've known very bad actors in the past, and that is not out of the realm of possibility in today's world. So I don't think any one person should have that kind of access over somebody's career and potentially their life. On a final note, is it right to deny justice, especially to our military troops who serve in the dual status of a guardsman serving the state mission and as a federal military member in the federal service? Is it fair to deny them their right to this choice because we say we don't have the resources, when it's obvious we do have the resources if the need is there? Thank you.
State Senator Lisa Krasner, proudly representing State Senate District 16. Vice Chair Daley, I'd first like to say thank you to you and the members of the Senate Government Affairs Committee for hearing this bill today. I'm very grateful for your time. The fact that somebody is a member of the National Guard and chooses to defend their state and their country should not mean that they receive less protections under the United States Constitution. I have the greatest regard and respect for every branch of military and every member of the military that chooses to go forth and defend our country, and for our brave veterans who already have gone forward and served our country and defended this country. Again, I want to remind the committee that just today I received this from the Wayne Thorley, who's in charge of fiscal here in the Legislative Council Bureau for the Nevada Legislature, removing the fiscal note. There is now a 0 fiscal note on SB 95. In closing, I would just like to say this bill, SB 95, will be for our National Guard members, the brave men and women that serve in the Nevada National Guard, moving forward. The bill is not retroactive. I urge your support of SB 95. Thank you.